after.
All right, let's see here. Okay, got a bunch of people. Good morning, everyone. This is Judge Nicola. Everybody over Zoom, if you wouldn't mind using your microphone until your case is called, please. Thank you. Can y'all hear me this morning? If you wouldn't mind muting your microphone, please. Let's see, who do we have? Oh, there we go. There's another person coming in. Thank you, everybody. If y'all, oh, there's another person. All right. Everybody over Zoom, please mute your microphones until your case is called. Thank you. All right, everybody. Good morning. I'm Judge Nicola. We all ready to proceed? Mr. Rev, Ms. Armbruster? Yes, everybody else? Where do we want to start today? Mr. Rev?
Your Honor,
Sure.
Good morning, Your Honor.
Good morning. How are you today?
I'm good. How are you?
Good.
I have legal essentials this morning.
Okay.
I will start with Credo Javier Gomez.
All right.
Case number 19 CT 1544.
Okay.
I will verify the injunction has been filed on showcase.
Okay. Just find it.
Mr. Rouse,
I have looked at it, Your Honor, and the state has no objection.
Okay. Just looking at it.
Two count information, refusal to submit to testing, first degree misdemeanor, third offense DUI more than 10 years. You can enter a no contest plea on both counts.
Okay.
And the terms of the plea agreement on the refusal are adjudication of guilt, 6 months of probation, there's no early termination during that period. A substance abuse evaluation, follow recommendations, no possession or consumption of alcohol, random screen, or cost of prosecution. This will be composite of count 2, which is adjudication of guilt, 12 months of probation, no early termination, 12 months revocation of driving privileges, $3,000 fine plus all fees that are associated, $50 cost of prosecution, DUI school concurrent with count 1, substance abuse evaluation, follow recommendations, to no alcohol provision, during bars, tax loans, public lounges, victim impact panel, 10-day impound, and a 2-year ignition interlock device. My client does reside in Miami-Dade County, so it has to be allowed to report by mail.
Any objection, Mr. Reb?
No objection, Your Honor.
Okay. Is that all of it?
Absolutely.
Okay, perfect. Mr. Verderama, you stipulate to a factual basis and venue for the purpose of the plea in absentia?
Yes.
All right, and I have reviewed it and I find that it is in order and that the signatures are on the plea and that we have the fingerprints that we need. So the court will accept the plea in absentia, find that there is a factual basis for the plea in venue in Collier County. To the first count, which is a refusal to submit to testing, there will be an adjudication of guilt, 6 months of supervised probation, no early termination, substance abuse evaluation, follow all recommendations, no possession or consumption of drugs or alcohol during the terms of the probation, random urinalysis or breathalyzer upon request and at his own expense. Court costs and costs of prosecution, which will be concurrent with count 2, DUI third offense outside of 10 years. The court will adjudicate him guilty, 12 months of supervised probation, may not terminate early, 12 months driver's license revocation, $3,000 fine plus court costs, cost of prosecution, DUI school appropriate phase, substance abuse evaluation, follow all recommendations, no possession or consumption of drugs or alcohol during the term of probation, no alcohol in his home, no visiting any bars, pubs, taverns, lounge, package stores, or places where alcohol is primarily served or sold. Victim impact panel, 10-day vehicle impound, 2-year ignition interlock, and the probation may be mail-in from Miami or wherever it is that he resides. Thank you. All right, just take a look at it. I know. You got most of it though.
I do.
Yeah. If only we could type as fast as we talk, right? Gotta get one of those little microphones and then just have it all like do it for you, right? Whenever I try that with my phone, it never comes out with what I said, right? It's never right. And then you push send and you read it and you go, oh my God, I shouldn't have sent that. Okay. Perfect. Thank you. All right. All right, Mr. Bergerama, you have another one?
Next case is Hugo Casero, CASEIRO, 19CT 2029,
Okay.
5. There will also be a change of plea.
Okay.
Number 150 under showcase will reflect the plea and essentially can enter the plea for DUI first offense. Terms are under paragraph 5 of the document. Adjudication of guilt, 12 months of probation, may apply for early termination after 6 months. 6-month revocation of driving privileges, $1,000 fine, plus any surcharges, costs of prosecution, DUI, school appropriate phase, substance use evaluation, no alcohol provision, possession or consumption, victim impact panel, 10-day impound, government service. The request to file at $10 per hour, to my understanding, probation, county probation, is only related to my house, so it's difficulty performing. He also lives in Broward County.
Okay.
So he'd ask for mailing probation as well. And we'll it's in Miami.
Oh, also Miami? Okay.
This is in Broward.
Mr. Rob, any concerns or questions?
No objection.
Great. And Mr. Bergerama, you do stipulate to a factual basis and venue for the purpose of the plea?
So stipulated.
And I have reviewed the plea in absentia. I do find that it's in order. The signatures and the fingerprints are of record. And the court will accept the plea, find that there is a factual basis for the plea and that there is venue in Collier County. To the charge of DUI, first offense, there will be an adjudication of guilt, 12-month supervised probation, may terminate early after 6 months and upon the completion of all terms. 6 months driver's license revocation, may obtain a work permit, $1,000 fine plus court costs and the cost of prosecution, DUI school appropriate phase, substance abuse evaluation, follow all recommendations. No possession or consumption of drugs or alcohol during the term of probation. No entering any bars, taverns, pubs, lounge, package stores, or places where alcohol is primarily served or sold. No alcohol in his residence. Random urinalysis or breathalyzer upon request and at his own expense. Victim impact panel, 10-day vehicle impound, 50 hours of community service, which may be bought out at $10 per hour. And he also may mail in from Broward or Miami or wherever he lives.
Thank you. And one other request, if he's eligible for a hardship license, we would like to adjust it.
Yes, I did announce that, but yes, I think we can put that on the record too. Okay, perfect. All right.
I know you.
Yes. See, you already knew before I even said it. Okay. Got it. Perfect. See, I know you too. Okay. And who else do you have, Mr.
Next
Verona?
case is Noreen Price, 19CT 2991. Ms. Price is also executed with the abstention. However, I'm going to ask to put that on the docket sometime in the end of March. Please stay on objection.
Okay.
We're in a resolution posture. I'm going to ask you to hold off on rejecting on this. Affairs and orders specifically with the vehicle.
Okay.
The lease vehicle. And if the judge goes in today, there'll be some repercussions that she has.
Any objection, Mr. Rob?
No objection.
Just trying to figure out how many police do I have on 2:30 on March 23rd? It looks like I have.
She's actually already said, March 23rd. You have 23 Saturdays.
Is she said on the 22nd?
She said on February 23rd. I just have 2,000.
She said on February. Oh, and you wanted me in March.
There's your calendar.
Oh, yeah. Okay.
It'll be a quick window.
Okay. Let's just put it on the 23rd at 2:30. No problem.
And go ahead and cancel February.
Yes. Since we already have an executed plea, I'm fine with that. Perfect. Okay. All right. Who else do you have, Mr. Verderano?
Next case is Jeffrey Ryan Hopkins, 19CT 1731.
Yes.
We are ready for trial.
Okay. Mr. Reb?
And Your Honor, the state does have a witness conflict with two EMS personnel. Unfortunately, we did not have their availability. One of them that responded to the scene is on FMLA leave. It is possible that that FMLA leave terminates the week of March 1st. However, it may be extended. And my understanding is that Collier EMS is unable to reach out to her while she is on FMLA leave.
What is FMLA leave? Is that like when you have a baby?
Family medical.
Oh, okay.
It could be for a variety of things, yes, Your Honor.
Okay,
The other EMS crew member is out on vacation through the middle of March. The state would request a continuance as a result of that. Other than that, the state is ready for trial. We haven't been in contact with.
see, Mr.
He's not a custody judge, so there's no.
Okay, then the court will grant the state's request for continuance. Let's put this on my April pretrial, which would be April 21st at 9. Okay, thank you.
Two more, Judge.
All right,
Marcos Santiago, 20 CT 1853.
okay.
Ready for trial.
Mr. Rep,
State is ready, Your Honor.
which week do we put that on? We put it on next week or we put it on the week of the 1st?
March the 2nd.
The 2nd, okay.
Madam Clerk is better than I.
It's right in front of me.
So we will put it on for March the 2nd. I expect that I will do a calendar call on March the 1st. I just haven't set it up yet.
Okay, I'll get notification.
Yes, sir. Yes. I'm probably going to do my calendar call for next week on Monday at 1:30 because Judge Foster has his calendar call at 9 a.m. And so I'm kind of waiting to see for next week whether Judge Foster's case is going to go. He indicated to me that he had a 4-day trial that was going to go. So I just don't know. I mean, Judge Manulich's trial docket ended up resolving or none of them went. So for me, I'm just kind of waiting to see what he's doing because if his cases don't go, then some of mine will probably go. Okay.
The last case I have is Osmarvin Cervantes, 20 CT 1819. This is a free trial for April 21st. It's a fairly new case.
Okay. Mr. Rav, any objection?
No objection, Your Honor.
All right. We'll put that on the April pretrial.
Good weekend, Judge. Thank you.
You too. Thank you. All right. Okay. Mr. Rav, who do you want to call next?
Any private counsel?
Yes.
Mr. Pizzazz?
Judge, Mr. Pizzazz and I actually represent a co-defendant, which we can approach together on the matter.
Sure.
Judge, Mr. Pizzazz represents Courtney Brodowski and I represent Philip Brodowski. My case number is 19-2166.
Okay. 266, did you say?
2166.
2166, okay.
Your Honor, I've spoken with Mr. Pizzazz outside. He's given me permission to bring this to Your Honor's attention. I was made aware of the pre-trial that the state had a witness issue, so I reached out to my client who told his ex-wife, who then told me that Mr. Pizzazz represented her. So I reached out to him and informed him of the state's witness issue. Neither of our clients are here. I did check the notes and realized that this was made to be a mandatory appearance. However, based on the fact that I knew the state had a witness issue this cycle, I informed Mr. Brodowski that he didn't need to be here to accommodate social distancing. So we just wanted to approach this matter together since it's
Okay.
the same issue.
Right.
My request would be to just put this on the next trial call, pre-trial docket.
In April?
In April.
Okay. Mr. Rav, any objection?
No, Your Honor, just for clarification, I thought that as it related to Ms. Brodowski, there may have been an issue with communication. As long as counsel is able to represent that he has been in contact with Ms. Brodowski, and that there is good contact, the state has no objection now for the trial.
Okay.
Yes.
And my only,
She did-
oh, go ahead, I'm sorry.
I'm just gonna answer that. She did contact my office ironically, at the last court date when we made it mandatory. She
Of
did
course,
say
right?
that The two of them were speaking, the both would have been talking, and so obviously they know that we have big issues. So.
They know that their lawyers were speaking, that there is an issue, and so I think Mr. Pizzazz and I each need to speak to our respective clients separately, because there was perhaps maybe some miscommunication, but regardless, the state does have the witness issue, because Mr. Brodowski, we'd be ready to go to trial this cycle.
Okay. And you guys have clients who are divorced and are talking to each other, so that's amazing in and of itself.
And Your Honor, just for clarification, I do believe that we have witness availability issue for 1 week. Twardowski, based on potential unavailability of her.
Okay.
He did allow us to not subpoena witnesses for the trial.
Okay, then let's put this on the April trial date, the pre-trial, I mean, and we can talk about it then. And truly, if you guys are communicating with your clients and you can represent to the court that you've had communications with them, that's the only reason why I was making some mandatory appearances, because I was worried that we had a few people that were just ignoring court dates or their lawyers.
I
So.
spoke with Mr. Kowalski like yesterday, and through text messages over the last.
Okay. So let's put them on that. What was
You
that?
want them all at the same time?
Well, Mr. Pizzazz goes on a separate day, so for pre-trials, I don't mind keeping him on the private docket.
Okay. So one would be on the 21st and one on the 22nd.
So mine's the 22nd.
Right, Mr. Pizzazz, you'll be on the 21st.
Very good, Judge.
Okay, all right,
Thank you.
thank you. Okay. Let's see, who do we have over Zoom? We have a gentleman on the iPhone. I can see you. But I can't hear you.
Mr. Baker, Your Honor.
Hi, Mr. Baker, how are you doing?
I'm doing okay, Your Honor. We're here today for Robert Arnold. It's for a
Okay.
status, Your Honor.
You're not ready for trial?
No, Your Honor, and here's the reason why I wanted to ask for a continuance, and I did send an email to the prosecution. At our last court hearing, I asked about a 911 call, and it turned out that there was a notice of discovery supplemental filed on February 14th. I didn't see anything come in until yesterday, and I asked if Miss Martorino, who's a very nice person, could send it to me in the portal. When myself and my assistant looked in the portal, we didn't see the additional 9 through 21 pages of discovery and the 911 call, Your Honor, in the portal, and I'm just kind of uncomfortable of it being set on the trial call for Tuesday with this situation right now, ma'am.
Mr. Ebb?
Your Honor, I am actually conflicted from this
21
case.
pages of the scope.
Everybody who's signing on to Zoom right now, please mute your microphone until your case is called.
Yes, Your Honor, I am conflicted from this case.
Okay.
Unfortunately, there is no one from the state right now present. I don't believe there's anyone who gives Zoom. I can message Ms. Mantorino and ask her to come down here for all that we're called. However, I imagine there's no issue.
Doesn't sound like there's an issue with the continuance, sir. So what we'll do is we'll put this on the April pretrial. And that way we can have the state attorney who's going to be involved in this case address it with you. That'll go on the April the 22nd at 9 a.m. pretrial conference. And is Ms. Matarino, is she the one who's going to be handling this case? Okay, so get in touch with Ms. Matarino and you guys can work out that 911 call issue, and then we'll be ready to go for the May trial docket.
Okay, I'll do that, Your Honor. It's
Okay.
nice seeing you again, and thank you, Mr. Prosecutor, also, and I hope you both have a nice weekend.
You too, sir. We'll see you soon.
Okay, thank you.
Oh, sorry, April 21st, sir.
Oh, April
Not the
21st.
22nd.
Okay.
Yeah, it's not, the 22nd is the PD pretrial, PD pro se.
Okay.
Okay,
All right, thank you, Your Honor.
thank you, sir. Okay. Let's see, who else do we have over there? Mr. Gorman, you ready?
Yes, Judge, thank you. I'm sorry, I have a deposition to get to shortly. Ours are relatively brief.
Okay.
Judge, first one we have is Edwin Clark, 20 mm, 656. We're ready for trial.
Mr. Reb, what's that?
State is ready. This is for the second.
Okay, this is set for the second week, Mr. Gorman. I
Okay.
expect that I will have a trial call on March the 1st. I just haven't set it up yet. My expectation is it'll probably be at 9 a.m. I just need to make sure that I've got clearance for that date and time, but I'll probably get that set up today.
Okay, very good.
All right, sounds good. Okay, next.
Mr. Clark's appearance is not needed for that trial call.
No, sir. I'll probably just do it by Zoom with the attorneys just to figure out where we're going to slot everything.
All right, very good. Next case we have is Sheehan Forrest, 19 mm, 2327, ready for trial.
Not yet. I will though.
State is ready, Your Honor, and this is for your first week.
Okay. So she and Forrest, we'll set this for a calendar call Monday at 1:30. Haven't set up that date yet either, but that's what I think I'm going to do. I think that makes the most sense.
Very
And
good.
that can also be a Zoom call. We'll just have have you guys zoom in and let me know where we're going to slot everything if Judge Foster's trial doesn't go. I don't know if you heard me, Mr. Gorman, but Judge Foster's got the trial week next week, but in his calendar calls in the morning on Monday, his expectation is that one of his 4-day trials is going to go. But for me, I figure I better just be ready just in case it doesn't. So we'll see.
Absolutely, Judge.
All right.
Next case we have, Judge, is Thomas Mangan, 20M1858. Judge, we set it here today as a status. Mr. Rabb has given me a new offer. We're hopeful we'll have a plea in absentia. We don't have it executed yet, though. Can we have some date, perhaps 2 or 3 weeks out, where we'll have that plea in absentia back?
I can give you March the 23rd at 2:30.
That's fine, Judge. Thank you.
Okay, we'll set it there. Perfect. Okay.
And then lastly, Judge, we have Marcus Marine, 19 CT 2668, ready for trial.
Mr. Rabb? And which week is this one on? Okay, so this will also be set for a calendar call on Monday at 1:30.
Thank you, Judge. That's all we have. Have a great day. Have a good weekend.
You too. Have a good weekend. Thank you. All right, Mr. Casassa, you ready?
I am, Judge.
You have Mr. Fowkes, 20 CT 109.
Judge, Mr. Fawkes got an unfortunate Valentine's Day gift. He was checked in the hospital with COVID. As of February 14th, he tested positive, so I anticipate he's not going to be available for at least 2 weeks from that date.
Okay.
Your Honor, Mr. Casassa, I don't have any contract. You have any objection to
I didn't hear that, Judge.
He said he objects to your continuance. He doesn't believe you.
He can object all he wants. And tell him my client will give him a big old kiss on the lips.
Oh, he's so gross. Okay. Oh. Okay, so let's move this one to that April, the 21st date, yeah.
What is that, Judge?
It's a pretrial, April 21st, 9.
Judge, I'm also anticipating meeting with Mr. Rabb at some point.
Okay.
Once again, Judge, his offer at this point is draconian, and I'm hoping to make it better.
I figured it was draconian, always is.
Sounds like a bias point of view.
Yeah, well, we could have him appear via Zoom for his trial if he'd like. That would be a new one, right?
Yeah, that's not going to work, Judge.
That doesn't work for you today?
It doesn't, Judge.
Not
Okay.
sure how we get started.
Can't they take the fingerprints in the hospital? I don't know. These are new times, Mr. Casassa. I don't know what to tell you. I will give you your continuance.
There are tribling times in the kingdom, Judge.
That's very true. All right, that's the only one you have today, right? So we're not gonna have a trial with you next week?
Doesn't look like it, Judge.
I've got a few others here in case you want one to try. No?
Give me a call, Judge.
Okay, I will.
Thank
All
you.
right, have a good weekend. Bye. All right, let's see. Attorney Camadeko, you ready?
Good morning, Your Honor. How are you?
I'm good. How are you?
I'm doing well. I'm here for Mr. Davidson, who is on Zoom, 20 CT 377. Your Honor, we're going to be reaching a resolution with the state. If we can get an in-person plea date.
Okay, my next in-person plea date is March 23rd at 2:30.
That works fine.
Does that work for you, Mr. Davidson? Thumbs up or thumbs down?
There he is, yeah.
There we go. He's muted, so. All right, we'll see you on the 23rd at 2:30.
Thank you, Your Honor. You have a wonderful day.
You too, thank you. All right, let's see, who else do I have over Zoom? I have Ms. Upson over Zoom. You ready, Ms. Upson?
Yes, Your Honor. Good morning.
Hi, good morning. Find yours. Who are you here for? I don't see you on the docket. It's under what? Why can't I find it? All right, well,
And Your Honor, the state has an announcement.
yes, sir.
Yes, Your Honor, the state announces a no crossing case 20 MM.
All right, Ms. Upson, it's a victory. Your case is dismissed.
Thank you, Your Honor.
Thank you. Have a good weekend.
Thank you, Mr. Rob. Bye-bye.
Bye. Mr. Levy, you ready?
Yes, Your Honor. Good morning. My
morning.
client is present also via Zoom. This is Frederick Johnson, case 20 CT 713.
Okay.
Judge, we had some new information come in yesterday and kind of the day before, and we were finally able to speak with a witness that we need to disclose to the state. I think in deference to them, we have to request a continuance to the next trial call date, just so we can disclose the witness and give them time if they wish to file a motion to take her deposition.
Okay. Mr. Rabb?
They would have no objection if they intend to use it.
Okay, so we'll continue this again to that April 21st date. And I would appreciate it if you gentlemen talk about the issue of whether a deposition is going to happen or not. If you guys can come to an agreement on it, I'll sign an order on it. That way we don't have a hearing on it and we can keep things moving.
I think we'll have her do a sworn statement, but I'll speak with Mr. Rabb prior. So if he wants to do one, we can decide if it's appropriate or not prior.
Okay, that works.
Thank you.
All right, thank you.
Have a good day.
All right, you too. Let's see, Mr. Fayette, you ready?
Ready, Judge.
All right, which one do you want to start with?
Doesn't matter.
All right.
We can go David Wright, Judge. Can we set that for a plea for next week?
I could do a plea Monday at 1:30 if you want. That's going to be my
works.
trial call, but I'm happy to do a plea then too.
Yeah, let's do that.
All right, Monday at 1:30. For a plea. All right, who's next?
Judge, then we can do David Tamiano, 19 CT 2875. My understanding is state's looking to get, they found out about another video possibly, and we're going to ask to continue it. I don't know where that's at.
Yes, Your Honor. So in full disclosure, there is a video for this incident. For whatever reason, it cannot be downloaded by CCSO. In other words, the officer would have to go and physically check out the recording and then bring it to us to watch. Mr. Fayette and I need to schedule time to allow the officer to do that and watch it with us. So the state requested a continuance.
All right, did you hear that, Mr. Fayette? The state is requesting a continuance, and it sounds to me like a continuance is warranted. So it will go on that April the 21st at 9 a.m. Date pre-trial.
Okay, that's fine.
All right. Okay, which one do you want to call next?
Roger Wiegand.
Okay. 19 mm 1518.
Mr. Wiegand, judge has been offered diversion. So if we could put him on for a pretrial, and I will get him signed up, and hopefully by the time we get to that pretrial, it will have fallen off your docket.
Any objection, Mr. Rabb?
No objection, Your Honor.
April 21st at 9. All right.
Mario Garcia Cisneros, 19 CT 1906.
Yes,
We're ready.
Mr. Rabb?
And Your Honor, state is requesting continuance. It is very possible that within the next week, the state takes alternative action on this case.
Okay.
However, this is, there was damage to two victims, both the person and property. The state is making sure we uncover every stone before we ultimately decide to take alternative action. That's the posture that we take. Mr. Fayette and I have been in contact, but we are asking for continuance.
So,
Any objection, Mr. Fayette?
yeah, Judge. So this is what's happened, and I've been talking about this for months. This is a JOA. They don't have a wheel witness. I provided them with transcripts of depositions that they attended to show them that, handed it up on a silver platter to tell them what problems they have. Now they want to root around with it. They've had the transcripts for a week. Now they want to root around and try and find another witness or some miraculous way to prove this. I'm literally, my face is red that they're going to ask to continue this after I give them this. No, I'm ready for trial. They're stuck with what they got. Tell me what they didn't have available to them prior to today. What's new?
A little mad.
Understandable, Your Honor. So just a little background. The arresting agency in this case was Florida Highway Patrol. This was a crash that occurred in Collier County. The initial deputies that interacted with the defendant were CCSO deputies, not FHP troopers.
Okay.
When the state requested evidence, the state got evidence from FHP that did not include dash cam video from CCSO.
Okay.
There were statements made on those videos. The state is trying to see if we can prove corpus via circumstantial evidence. It is very possible we are not. However, before we make a determination to do that, because there are two victims in this case, we want to make sure we uncover evidence as a result of that. You understand that is the situation of the state.
What week is this set for?
February 23rd.
And it's almost 2 years old, so.
So it was set for next week, Your Honor. with the posture of Judge Foster potentially going anyways.
And it may not go. I think we just leave it as set, Mr. Rabb. I understand your predicament, but it's been going on for almost 2 years. And I feel like we should just let it play out the way that it should. And Mr. Fayette, it's very possible that this case may not end up going next week because Judge Foster has indicated to me that he has a 4-day trial starting Tuesday. But, you know, a calendar call, things happen. So it could happen. But, I'm looking at my notes on this, and there was like a no further continuance note on this a year ago that I put on there. And then I guess I've been allowing everybody to kick the can on it because of COVID and because of the fact that we haven't been able to have jury trials. But now we are going to start having jury trials again. So if something miraculous comes up on Monday and it looks like we're going to have this trial, Mr. Rabb, and you say, I have just uncovered the pot of gold at the end of the rainbow, and it's going to be surprising to Mr. Fayette, we can address it then. But I understand Mr. Fayette's frustration. So I think I'll leave it as set and we can just see how it plays out. Okay.
And for the record, Judge, or whoever's also on there, my mistake for being professional and courteous and showing them where their problems were. If I hadn't given them that stuff, they'd have no idea what's going on. They'd have announced ready and pressed me. They pressed me up to this point. The only reason they're asking for the continuance is because I told them what their issues were. My mistake.
No, you know what, Mr. Fayette, that's actually not a mistake. I actually think it's good for defense attorneys and prosecutors to work together to try and figure out what the flaws are, because that's what makes trials go or it makes them not go. I love the fact that the defense bar and the state attorney's office work so well together. I've been so surprised by that. Well, and I understand you're upset, Mr. Fayette, but I don't consider that to be a mistake at all. And I understand the state's position. Mr. Rabb is new to this case, and he has to do his due diligence. And so, I mean, I don't find that he's intentionally doing this to try to thwart your client, Mr. Fayette, but at the same time, I understand your frustration. So let's leave it as set on Monday. And maybe Mr. Rabb, between now and then, you'll know whether you're going to get something or not. And CCSO may give you nothing, or they may say, we have it, we can't find it. I don't know. This case is 2 years old, so we got to resolve it. Okay, thank you. All right, Mr. Fayette, now you're not read anymore? Are we ready to move to the next one?
Yes, Judge. I showed, so I was looking, there was confusion. And when I look at it, Bernard Duran, I thought was on this docket, but I
don't see anybody on this docket other than that one.
I apologize. It shows on my schedule, but then when I looked it up, it didn't be there. I just want to make sure. Okay, I appreciate your time.
All right, no problem. We'll see you soon.
Have a good day.
You too. So that one will be 1:30 on Monday too. Okay. Let's see. We also have Mr. Lucarelli. You ready?
Good morning, Judge. Yes, I am ready. We've resolved that case, Judge. If I could have a little continuance to get a plea in absentia put together, this case will come off your docket.
Mr. Wade, 19 MM 1285. Do we want to set this for a plea in absentia on the 23rd? I'm just loading that docket up.
That works.
Okay. It'll be March the 23rd at 2:30.
Thank you, Judge. Have a good day.
Right.
Thank you, Rob.
You too. All right. Thank you. Let's see. Who else do we have on here? Mr. Villacava, you ready?
Joe Villacava, Your Honor.
Miss Villacava.
I just wanted to confirm there's a little.
Right. It does say
Okay,
Joe.
well,
you don't look like a Joe. Maybe you are Joe. Joseph, to be precise.
I'm just standing it.
What is your name?
There's two Villacavas. That's my list. So, Your Honor, we received a phone call from the state yesterday that they were going to give us additional discovery in Mr. Weeks' case, medical records, as well as, I believe, something to do with phone calls. I think Mr. Rob could address it better than I can. I did give a motion to suppress to our assistant to file on February 11th. Unfortunately, it wasn't filed, so she just filed it today. So that's where we stand.
Harold Weeks. And for the record, this is Harold Weeks, 19 MM 1583. I just don't see a motion to suppress on my dashboard. Mr. Rabb, what's the state's posture with this case? This one's old too.
Yes, Your Honor. So as announced, speaking with one of the victims, came to our attention that there was potential serious bodily injury as a result of the crime.
Okay.
In this case, because of that, we have requested medical records. We were given medical records by a civil attorney. We have started the process to disclose that to defense counsel. In addition to that, we found out that there was a cell phone video that at least captured part of the incident.
Okay.
That was never mentioned to CCSO deputies at the scene. We have requested that from witnesses as well. We have not received that yet. And obviously we'll disclose that to defense counsel once we receive it. Because of that, Your Honor, I don't think either side of the missing evidence is necessarily ready. However, this is continued to be placed on the docket. As long as defense counsel is aware that there will be late disclosures with potential evidence, the state is ready to move forward.
Doesn't sound like the defense counsel is ready to move forward with that. Are you, Ms. Villacava?
Ms. Augustine, Your Honor, for
Oh,
Joe
Augustine.
Villacava.
Thank you.
Not a problem. So it was difficult to hear Mr. Robb, but what I think I heard is he is going to disclose medical records and a cell phone video to us.
Yes.
So we're not ready, Your Honor. Our assistant is, she did file it, but apparently not with Collier County. She's refiling our motion today. We would request a continuance based on the new discovery. And if Mr. Robb can tell us how many minutes he would need to argue his side of the motion, that would be appreciated. Also, Mr. Robb, Mr. Villacava would like to discuss a potential resolution with you.
Okay, so lots of things going on. So first of all, let's set this for the April 21st pretrial at 9 o'clock in the morning. And Ms. Augustine, have you provided the motion to suppress to the state yet?
Well, I have not directly emailed it to them, so I will do that today.
How much time do you think
I have not, Your Honor. I thought it was filed with the clerk, so that's why I didn't directly email it to him, but I can do that today.
What are you seeking to suppress?
We're seeking to suppress our client's identity, the observation of the injury on our client's hand, photographs of the white Porsche, photographs of the defendant, based on an illegal stop, and statements. Having said that, it's not dispositive.
Okay, that sounds like an hour, probably, maybe an hour and a half. So we're gonna, what's that?
I agree.
Okay.
I agree with you, Your Honor.
So what we're going to need to do is get a hold of my judicial assistant and also talk with Mr. Robb. And we need to find an hour to an hour and a half between now and April, which I'll just have to carve out some time. I don't want to really necessarily put it at the end of a criminal motion docket because the motion to suppress is going to take some time, and I want it to be heard before the April trial sounding. Yes, sir.
I'm not sure if the defense plans to call on witnesses for the motion to suppress. Under the state, probably only needs a single witness who made the stop on the vehicle.
Okay.
And I don't imagine that. I can't imagine any more than an hour.
Okay.
I did not hear him, Your Honor. I apologize.
He said that he probably will have
I
one.
cannot hear.
He said he probably will have one witness and can't imagine that it would take more than an hour. And
Okay.
so I will figure out a time that I can schedule some criminal motions between now and the April pretrial. All right, so just you guys get a hold of
Thank you, Your Honor.
and we'll set it up. Okay, thank you. And that's the only one you have, right? Ms. Augustine, I lost you.
I'm sorry. Yes, Your Honor.
All right, thank you. Have a good day.
You too.
All right. Mr. Suarez, you ready?
Good morning, Your Honor. Yes.
Good morning, sir. And let's see here. Who are you here for, sir?
Brett Allen Jameson.
There we go. This is 20 MM 710. And sir, what are we doing for Mr. Jameson?
Defense is ready for trial. However, we did recently disclose a witness statement to the state. So if the state requests a continuance, the defense does not have an objection, but otherwise we're ready.
Mr. Rep?
Your Honor, the state was ready until the disclosure of the potential statement. This was originally set for your second week. It think it's best posture probably to just set it right now and for the calendar call. And
Okay.
if there are any issues with the additional statement, the state will make it.
Okay, sir, I expect that the calendar call will be on that Monday, the 1st at 9 a.m. I just haven't set it up yet, which will be by Zoom. And you gentlemen can talk about this witness and what this witness is going to say before then, and then we can see whether it will be continue to be in trial posture based on what the new witness has to say. Does that work?
Very well, Judge.
All right, sounds good. We'll see you then.
Thank you. That's all I have. You have a good day.
You too. So we're going to leave it set for that March the 2nd date, and then I'm going to make sure with Jen that I can actually set a 9 a.m. calendar call for that day. I think we've got, what, 3 so far that are set?
I'm sorry, Judge, for the 2nd or the 1st? I thought you said the 1st.
The first. The 2nd is the start of the trial week, because we can't do jury trials starting on Monday. So what everybody's been doing is setting up a calendar call on the day before. The one for next week is set at 1:30 because Judge Foster has the primary trial week and his calendar call is at 9. But the second week, the March 1st date, I believe I will be setting up a calendar call at 9. I probably should have done it already, but I just didn't get to it.
Understood, Judge. We'll be looking out for it.
Yeah, you'll get a Zoom notice from Jen. Okay.
Got it, Judge. Thank you. Have a good day.
You too. Thank you. Yes, sir. Yes, ma'am. Sorry.
In terms of setting up the calendar call that I would be part of, I just want to let you know I have the court and court with Judge Adams next week.
Okay.
Specifically on Monday, so I didn't know the cases that I set for calendar call if they could be done before I had one so that I could get to 24/7.
Probably. Yeah, we can do that. We'll accommodate you. We'll figure it out. Sure. Okay, who else do I have over Zoom? I have Ms. Fish over Zoom. You ready, Ms. Fish? Still muted. There you go.
Yes, I'm sorry about that.
That's okay.
This is
Who are you here for today?
a plea in absentia, Stephen Gabbard, case number 20MM1035.
Okay.
And we have filed it, and you should have that. It is statute number. Okay, so it's violate injunction for protection against domestic violence. And this will be a withhold of adjudication. Our client is entering a plea of no contest. The probation terms are 12 months reporting probation that may be transported to Citrus County where he lives. And the following conditions are: may not petition for an early termination of probation, a global positioning system, mental health evaluation, follow any recommendations, no contact with Brittany Christopherson or Brittany's mother, Tiffany, or DJC, who is a child. No trespass to 2430 DeSoto Boulevard South, Naples, Florida, 34117. Court costs amount to be determined and $50 cost of prosecution.
Mr. Rabb, is there any objection to the plea in absentia? Is it approved?
Your Honor,
Sure. Of course. I do see the fingerprints and the signatures, so we're good there.
Mr. Stewart has reviewed this.
State's in agreement? All right, perfect. Ms. Fish, do you stipulate to a factual basis and venue for the purpose of the plea in absentia?
Yes, Your Honor.
All right, and the court has reviewed the plea in absentia, does find it to be in order, and this is case number for the record 20MM1035, Stephen Gabbard, to the charge of violating a DB injunction for protection against domestic violence. The court does find that there's a factual basis and venue and will accept the plea in absentia as follows: 12 months of supervised probation, may not terminate early, may not petition for early termination nor terminate early, global positioning system, GPS monitoring, mental health evaluation, follow all recommendations, no contact with Brittany Christopherson or Brittany's mother, Tiffany, or DJC, a child, which means no direct or indirect contact by mail, email, fax, phone, text, communication applications, social media, or through any other means or any other person. No trespass at 2430 DeSoto Boulevard South, Naples, Florida, 34117. Court costs, cost of prosecution. Sounds like that's everything, right?
And may transport to Citrus County.
That's
Correct.
right, I forgot that. Yes, may be transferred to Citrus County or wherever it is that this defendant resides. Okay?
Thank you.
Thank you. Have a good day.
Have a good day. Bye.
You too. Bye. All right, let's take a look at this real quick.
Is they already called our case?
Looks good, thank you. Jose, what's your name, sir? Sir, up at the top, I see your name is Jose, but I don't see anything else. What's your name?
Jose Murillo.
Mr. Murillo, hold on a second. Okay, Ms. Armpriester, what are we doing for Mr. Murillo?
March, so long as it was addressed today at our court date.
Okay. You said she gave you March 31st?
She gave us March 30th, but then I had indicated to her that this was set for your Honor's first trial week, and that I didn't want to willingly just let it get kicked another 6 weeks when it was set. I just definitely.
Okay.
So while I wanted to try to handle it as quickly as possible, this isn't a backdoor way to get an extended continuance. It's really just a way to assist me in preparing for trial and adequately representing Mr. Murillo's practice after evaluating the case and speaking with my supervisor.
Mr. Kavrakis, can you hear what your lawyer's saying?
Not really.
In a nutshell, she's asking the court to continue your case because she would like to take the deposition of the alleged victim in this case, and that will take some time, meaning that we wouldn't be ready for trial in the next 2 weeks, that it would be set on my April pretrial docket, which would mean likely a trial in May.
Okay.
And you understand that, sir?
Yes.
Okay. Yes, sir.
Yes, the state is objecting. This isn't this. Cases deposition should only be taken in really extreme circumstances. The victim in this case has provided a page and response statement. I'm not sure what else can be said in a deposition that is not said in this small statement. I'm happy to work through this.
Judge, are we arguing the motion this morning or in March?
It's not set for this morning.
I'm not prepared to argue my reasons for the deposition.
State is ready, Your Honor. As Ms. Armbrister stated, this case was set for next week originally.
I have the same comments that I have the same comments that I had before that I said to Mr. Fayette and to you, Mr. Rabb. This case is almost 2 years old. It's going to remain set on Monday, and we can address it then. As I said before, it's likely that next week will not happen because Judge Foster has a 4-day trial set, but I'm starting to get concerned, particularly with cases that are almost 2 years old, that all of a sudden additional things we need to do, additional evidence that's appearing, and a lot of last minute scrambling, and my job is to stop that. So
I understand that the state hasn't made an offer that it's not.
she wants a trial.
I understand that, but she also isn't speaking with me, and in order for me to, and that prejudices me in terms of preparing for trial, which is the standard in misdemeanor depositions.
That she won't speak to you?
Well, that I can't adequately prepare for trial. I understand there's a sworn statement, but she's not going to come in and just read her sworn statement. The officer's not going to just read her sworn statement to the jury. I have no idea what her body language is going to be, her tone, her demeanor. And in order to adequately and zealously represent my client in a case that is this old, I'm not going to offer. I didn't let me reach out to the victim, let me reach out to the victim. Well, last week that there is no offer. So in order to do my job, and the fact that we're probably not going to go next week, I will not be doing due diligence in the case. I didn't bring this motion to the court. Mr. Murillo, our criminal history does not violate conditions of pretrial once. I understand the victim wants a trial, but Mr. Murillo brought this up right too.
Of course he does. And my question is, this has been going on since November 8th of 2019, 469 days. And in 469 days, nobody can figure out that this victim wants a trial and doesn't want to talk to the defense attorney and is digging in her heels and saying, I don't want to make a plea offer, I want a trial.
No, because I wasn't told that. I can expect it.
The state isn't required to make an offer. They're allowed to say, we're not making an offer, we're going to trial. I mean,
They didn't until 10 days ago.
Mr. Rabb.
Your Honor, I do believe, and again, it's not first or not, I do believe there was communication prior to counsel at various stages on both sides, stating that the victim's statements that she did want a trial, was not interested in a plea offer. As the court pointed out, the state does not need to make a plea offer at all. And again, the issue at hand is whether or not the deposition would be proper as it relates to the preparation of this case. This is a misdemeanor case. There is a substantial sworn statement. I understand that this is not the time to hear the motion. But again, Your Honor, the state remains ready.
So here's what we're going to do. We're going to set it for my calendar call 1:30 on Monday. And we're also going to schedule the motion to take the deposition at 1:30. 1 o'clock. The 22nd, Monday. And sir, you're more than welcome to Zoom in, or you could come in person if you would like, because we're going to hear that motion to take the deposition on Monday, as well as it will be a calendar call. If I deny the motion to take the deposition and your case is first up, it will go to trial next week if Judge Foster's case does not go. So everybody needs to be in trial posture for this case as well. All right, Monday, 1 o'clock. All right. And Mr. Russo, are you ready, sir?
Yes, Your Honor. I have Andy Jacinto Guerra, case number 20 CT 1151, and the defense is ready for trial.
You're ready for trial? Okay. And this is 20 CT 1151. Mr. Rabb, you ready? What week is this set for? Set for the second week. Mr. Russo, I expect I'll be doing a calendar call on Monday, the 1st at 9 a.m. I just haven't set that up yet. But we will set that up and give you notice of it, okay?
Okay, will that be Zoom or in person?
It'll be Zoom.
And client appearance required at that time?
I'm not requiring the client's appearance. They're certainly more than welcome to Zoom in if they would like. But I trust the counsel will be able to let the client know what day they'll be set for.
Okay.
Haven't had a problem with it thus far. That's why I haven't been requiring people to come unless, there's a problem. Okay? All right, thank you.
I'm so sorry, Miss. You wanna do I have to be there on Monday or
you don't have to. No, you're welcome. You're welcome to Zoom in. You don't have to be present, but if you would like to, you're welcome to come in person, or you're welcome to appear by Zoom, or you can allow your attorney, Ms. Armpriester, to represent you. You don't have to be here, but there's going to be several things that are going to be addressed on Monday. One of the things that's going to be addressed is that your lawyer has requested to take the deposition of the alleged victim in this case. And I'm going to hear that motion on Monday. And I'm also going to have a calendar call on Monday to determine whether your case may go to trial. Okay?
All right. Thank you so much, Your Honor. I'll Zoom in on Monday.
Okay, sounds good. All right, thank you.
Thank you.
All right, bye-bye. Okay, it looks like we also have a regional counsel case, but he hasn't come in. Ms. Armpriester, would you like to call your cases? Okay. Okay, Mr. Elwer? You may, of course. Yes, sir. There's, and this is 2019 MM2150. Good morning, sir. And which week is he set? All right, so there will be a calendar call the second week, probably at 9 a.m. You know what? Let me call Jen and make sure I can do it, because I'm going to be setting a bunch of these. Might as well do it right now. Hi there. I'm setting up a calendar call for next week, starting at 1:30 for one for Ms. Armpriester, because she has 24, is 1:30 for the private counsel. But the week of March the 2nd, could I do a calendar call 9 a.m. On the 1st? I don't have anything that's conflicting, right? Exactly, that's my primary week. Okay, so let's set up a calendar call for March 1st, and then I'll do Zoom codes for that. All right, thank you. Okay, bye. Okay, we're gonna set that up. So March 1st at 9 a.m. will be a trial call. You don't have to be here, but you're certainly welcome to come because we will be figuring out which days certain cases are going to trial. We have a lot of cases set for trial, so we're gonna have to figure out which ones have priority, but it's possible that yours may be one of them, sir. Okay? And so that will be where we are right now. Thank you, sir. March 1st at 9. Okay, perfect. So his case is set for trial the week of March the 2nd, and we're gonna do a calendar call on March 1st at 9 a.m. Oh, no problem. Okay. Of course. I'm actually. What are you doing? Yes. Yes. Okay. I should have done this before today. Just been one of those weeks. Feel like I didn't have 5 minutes this week. Been crazy. Yeah. The guy that we just did. Okay, it's totally out of my brain. Mr. Russo's client? That was Mr. Russo's client. Oh, this gentleman, Mr. Elwer, E-L-W-E-R. Yes. Yeah. Oh, no problem. I'm probably making it more complicated than it needs to be today. All right, Ms. Armpriester, who's next?
Courtney Brown.
Is she here?
No, I haven't contacted her. I have no notifications.
2019 MM 2263. This sounds like a bench warrant.
Yes, Your Honor, in both cases. The first one was 19 MM 2263. I believe there's a later case 20 CT 8 stated requesting that warrant purposes.
All right, let's see here. 11/19, 12/19. Defendant not present. She already was bench warranted once and picked up. Renotice to appear. I'm just trying to see if she's appeared since then.
She's not, Your Honor. I've had my investigator.
7/16/20, not present. 10/28/20, not present. 12/3/20, not present. 1/7/21, not present. 2/11, not present. Made her presence mandatory for today. Still not present. Nobody can find her. She's got 2 cases, 19 MM 2263 and 20 CT 620.
80. Oh, I'm sorry.
820?
No.
This print is so little. Yeah, 820. Okay. Yes, 20 CT 820. I'm looking at that one right now, and she hasn't been present at all in that case either. So on both cases, in each case, there will be a bench warrant, a $2,500 bond, total bond $5,000. I'm not RORing her. She's ignoring the court, and she's ignoring you, Ms. Armpriester. So it needs to be a little bit painful for her at this point. Yes. 20 MM 265.
That's the only mitigating factor. I would again ask for an ROR. There's potential competency issues with Mr. Cavens. And while I do believe perhaps a warrant is, I don't want to say necessary, all warrants perhaps what the court will end up doing, I would request that it be ROR based on potential competency issues.
Your Honor, say with the plus of bench warrant and for the monetary bond, perhaps the monetary bond continue to hold him, there could be a competency evaluation for that matter, and resolution is appropriate.
I'm just looking at the booking sheet. I'm not saying that there isn't a competency issue, but I don't see anything in the booking sheet that indicates a competency issue.
It's through our office.
Okay. I mean, the suggestion that I see, at least from what I'm reading, is that he's potentially a drug addict. And maybe that's why he doesn't want to come into court. But I am going to issue a bench warrant, and there will be a $2,500 bond. And that's for both counts. And then we'll see what's going on with him. Oh, was one of the counts not filed on, Mr. Rabb? I thought I saw two. But it's still the order of the court will be $2,500.
The POP was no filed.
Okay. All right. Who do we have next? Why don't we start with people that we have in the courtroom?
If we could.
So we can take care of them and get them on their way.
Yes, Judge. In that case, then I have pleas.
Okay.
I'm not sure if you want to call them at the end or.
No, let's take them now. They're here. Let's let them.
Mr. Carlos Martinez.
All right, Mr. Martinez, come on up. And this is case number 20 CT 576. Of course. Thank you.
Withdrawing or pleading clear.
Just pull it up. Give me one quick second. And
Your Honor, also at the appropriate time, if we may have Your Honor weigh in on the issue of the impoundment. Mr. Martinez is the sole provider for his son. That is a family tie. That's how he gets his son to school. He will be applying for a hardship as well. We would be asking if the court could waive the impoundment.
Mr. Rabb, if you look to see if this is the only vehicle that's in his household, can we verify that?
I have not, Your Honor. I would request that the issue of the impoundment be held until either last month's probation, all additional conditions have been completed, and to determine whether or not this is in fact the only vehicle. My fear with potentially doing it now is there is always a possibility that if you waive an impoundment, that it's going to go out by another vehicle. It matters that if you waited for maybe result in regulation.
Yes, let's address that issue later, Ms. Armpriester. I'm always available to hear that issue. I do think it's a little bit premature.
The only issue, Judge, is he would then have to, he won't be able to have an attorney on that once the case closes, and then I wouldn't be able to bring a motion, and I'm not able to represent clients until there's a violation with an application attached to it.
What about that issue, Mr. Rabb? How do we bring it forward? How do we bring it before the court?
I do understand some concerns, concern regarding representation, but I do think it's proper to weigh in on it at this point, as it does allow any defendant, not necessarily this particular defendant, but any defendant to particularly go around the issues of why this court and in fact waive the impound during probation.
Judge, he's not trying to get around, he's just trying to take his son.
Raise your right hand, please, Tony.
You solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth.
Yes.
And I understand his predicament. What I think is though, is that I agree with Mr. Rabb that there wouldn't be anything to prevent him from obtaining another vehicle or having a different circumstance at the end of his probation when the court addressed it. So it does seem a little premature to me.
My understanding is that this issue has been handled at least with other attorneys before, so that's why I was of the impression that I could bring it up as a plea.
I don't think, not with me, I don't think. I don't remember ever having this issue brought up at the plea, unless there was some other issue out there, but I don't remember ever doing it. Doesn't mean I haven't, I just don't remember it coming up at the plea. Do you, Mr. Rabb?
Your Honor could make a note, since it would come back in front of you, just should he bring the motion himself. I don't want him to be prejudiced by not having an attorney or not having the avenue to even apply for one to bring this motion when the time comes. I don't even know if there's a way in the judgment and sentence that the impoundment is waived until the last month. So I'm just trying to assist him.
Well, I was thinking that we could order it and reserve jurisdiction on the issue of whether to waive it later toward the end of his probation.
And Your Honor, I do believe that while he's on probation, probation themselves may be able to resolve that issue with the impoundment.
Well, my understanding with what probation has done is they've only ever waived the impoundment if they found that they didn't actually own a vehicle. And then they wanted it brought before the court if they owned a vehicle and then they were saying that they had a hardship that they, you know, because of having a child that they need to take to school or they had no other transportation for work or something like that. That's just been my experience with probation but you know, if probation determines that it could be waived, I'd be fine with that. I think that we need to reserve jurisdiction on it. And I'll always allow him to represent himself, call my judicial assistant and communicate with the state attorney and say, I'd like to bring the issue about the impoundment. You just need to do it before your probation terminates so we can take care of it. But I'm more than happy to hear it and even hear it on a pro se basis. Yes, toward the end of it. No, it's not going to be impounded today. What happens is that we give you an amount of probation. It has to be done within the term of your probation. So before your probation terminates, you know, I don't know how long the probation is, but before it terminates, you just you'll get a hold of my judicial assistant, Jen McAllister, and all the information about me and my assistant. You can find it online. You just Google it. It's super easy. And say, Judge Nicola told me my car has to be impounded. Could I get some hearing time so I can come in and tell her why it shouldn't be? And she'll give you time. We can always accommodate you, and I'm happy to hear it. But I think we shouldn't address it today. Okay, does that make sense to you, sir? Hardship? I have no idea. It's up to the DMV. But this appears to be a first offense DUI, and I think that they usually do unless there's some reason not to, but I don't have any control over that. All I can say on the record is that I'll allow you to get a hardship, and then the DMV makes that judgment call. Okay, all right.
And Your Honor, for
Yes.
the offer, this offer, again, was contingent on Mr. Martinez completing the U.S. with the answer she has done.
Great.
Counsel has provided proof of that to our office. An adjudication of guilt, $500 fine, 12-month probation, which may only terminate at 6, 6-month driver's license suspension, DUI school, which as I mentioned has already been completed, victim impact panel, substance abuse evaluation, follow recommendations, random testing, no alcohol provision, 50 hours of community service. The state does not have an objection to a buyout if the defendant would wish to do that, or any combination thereof. 10-day vehicle impoundment for cause and false prosecution.
We wouldn't be asking anything more than
Okay, perfect. All right, so we have already had you sworn in, sir. So please state your full name and your date of birth for the record. And sir, you've been charged with driving under the influence, first offense. Do you understand that the maximum amount of time that you could be sentenced to would be 180 days in the Collier County Jail? And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? And sir, have you read and signed a plea form? Do you understand all the rights that you'll be giving up by entering into this plea? Are you entering into this plea because you believe it's in your own best interest? Has anyone threatened you or made you any promises to get you to enter into this plea? And sir, you've been represented by Ms. Armpriest. Are you satisfied with her advice? Do you have any questions for her or for me before we continue with your plea? Other than that which we just discussed. I'm happy to answer any questions you have. Do you have a question? You can ask me anything. I'm not gonna, you know, if I can answer it, I will. I do my best to be fair with everybody, sir. So if you have that issue come up before the end of your probation, I'm so happy to accommodate you. I just need to have a hearing on it to make that determination then versus today, but I will. Okay? Certainly don't want to prevent somebody from being able to take care of their children or to affect their livelihood. That's not the goal here. Okay? Is his license suspended? It shouldn't be, right? Isn't there? I don't remember what the DMV rules are anymore. I used to be a defense attorney myself a long time ago. They used to suspend your license for a period of time and then they would give you a hardship. So I would say that if you can't drive home today, that you shouldn't, because that would probably be a very bad result for you. So yeah, let's make sure that he can drive. Okay. I don't know. Okay. All right. Are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you understand that if you're not a United States citizen, that this plea would likely be used against you in a deportation proceeding? Do you understand that a DUI is an enhanceable offense, which means that in some circumstances it can be charged as a felony? It can also be used as a basis to further suspend your driving privileges. Sir, have any other questions we need to ask this gentleman? Okay. Ms. Sergeant Priest, are you stipulating to a factual basis and venue for the purpose of the plea? So, sir, I will accept your plea. I will find that there is a factual basis and venue in Collier County. Also that it was freely, voluntarily, knowingly, and intelligently made. To the charge of driving under the influence, the court will adjudicate you guilty. There'll be a $500 fine plus court costs, the cost of prosecution, and the public defender fees. 12 months of supervised probation, which may terminate early at 6 months and upon the completion of all conditions. 6 months driver's license revocation, may obtain a work permit. DUI school appropriate phase. Court notes that you've already completed that. Thank you for doing that. Victim impact panel, substance abuse evaluation, follow all recommendations. Random urinalysis or breathalyzer upon request and at your own expense. No alcohol during the term of your probation. No alcohol in your residence. No visiting any bars, pubs, taverns, saloons, or places where alcohol is primarily served or sold. 50 hours of community service, which may be bought out at $10 per hour. 10-day vehicle impound. The court will consider your request at a later date to waive that impound, sir. And I think that's everything. Okay? Thank you. Good luck to you, sir. Sure, I just need to approve this judgment real quick. Okay, that looks good. Thank you. All right, and this gentleman's name again, I'm sorry? All right, just give me a second to get caught up. All right, Mr. Rusi, how are you today, sir? Good, so far so good. All right, oops, I just clicked on the wrong case. Okay, and what is the resolution for Mr. Rusi? Okay.
Trespass at Walmart located at 50 times Airport Pulling Road in Nicola. Court class prosecution and health energy. May I proceed?
Yes, ma'am. Thank you. All right, sir, we need to get you sworn in.
You are about to give a description. Thank you. All right, sir, can you please state your full name and date of birth for the record?
And sir, you've been charged with petty theft. Do you understand that the maximum amount of time that you could spend in jail for that crime would be 364 days in the Collier County Jail? And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? Do you understand all the rights that you're giving up by entering into this plea? Are you entering into this plea because you believe it's in your best interest? Has anybody threatened you or made you any promises to cause you to enter into this plea? And sir, you've been represented by Ms. Armpriester. Are you satisfied with her advice? Do you have any questions for her or for me before we finish your plea? And are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you understand that if you're not a United States citizen, that this plea would likely be used against you in a deportation proceeding? Thank you. Mr. Rab, any further questions for this gentleman?
Yes, Your Honor. You understand that the control of theft is an intangible crime, that if you are found to commit this crime again in the future, you may be subject to additional penalties, longer jail sentences, and possibly felony.
Thank you. I always forget that part. Okay, Ms. Arnpriester, do you stipulate to a factual basis and venue for the purpose of the plea? Sure.
Mr. Reese and I already handled this with Mr. Rapp. He has a plane ticket to go see his mother for her 90th birthday over the Easter holiday. I've seen the ticket there and the return ticket. We're just asking that there be no issues with that.
Of course not. Absolutely. Do we need an order on that? I mean, usually you ask probation, but
Probation until probation denies him that ability. I don't think it's order is appropriate. I don't
Okay.
see it being an issue because he does have the return ticket and it's been bought for a month.
of course.
I can put on the judgment that the court approves his travel
Yeah, of course.
for the Easter holiday.
Yeah.
And the state has no objection, Your Honor, just as long as it is with probation at a time.
Okay.
Additionally, there is no execution note in this case.
Okay, great.
If it could go in the judgment, then that his travel over the it's the end of March to see his mother.
Okay.
End of March, yeah.
Is that what it says to say? What do we need?
27th return on the 5th, the day after Easter.
March 27th to April 5th.
Yes, ma'am.
Thank you.
And if any of that changes, just get it approved through probation. I mean, I don't think it'll be a problem. And if there's an issue, just bring it to me and I'll approve it. I want you to be able to go see your mom, of course. Sure. Okay. No problem. So the court, what's that? Thank you. I'm duty judge over Easter, so that's super fun. I drew that card. Oh, they can explain to you what that means. Anyway, the court will accept your plea. We'll find that there is venue and a factual basis for your plea, and that your plea was freely, voluntarily, knowingly, intelligently made and entered. To the charge of petty theft, court will adjudicate you guilty, sentence you to 6 months of probation. As a condition of that probation, you'll serve 10 days in the Collier County Jail on the weekend work program, which you also may do at weekend work, straight time, or weekend lockdown. You will attend and complete the ACF milepost program. Also, there will be no trespass at Walmart located at 5010 Airport Road, Naples, Florida. Did I say the cost of prosecution and public defender fees? I don't know if I did, but if I didn't, I'm saying it now. All right. Good luck to you, sir, and enjoy your time with your mom. 90 is a big milestone. That's great. That's great. Thank you. Okay.
Yeah, right after court. Judge, next would be Darius Fuller, 20 MM 172.
All right. Just give me one quick second because I need to approve this judgment. It's not quite done yet. You're like, oh, thank goodness. It's not me. Maybe there's another Darius Fuller in custody. I don't know.
I'm gonna say he's never been in custody when I've spoken to him.
We had a gentleman named Fuller that was in custody on Tuesday, but it wasn't Darius. Was it Taylor or Tyler? I don't remember. Okay. Perfect. Yes, I think so. Yeah. Thank you. All right, let me just find your case, Mr. Fuller.
20 MM 1722.
All right, 20 MM 1722.
We were trying to create a plea of not guilty for a plea of no contest.
Okay.
Adjudication, cost of prosecution and defense, as well as cost of investigation in the amount of $545 to the sheriff's office in Tyler County. We request 90 days to pay.
Okay.
May I approach with the next few?
Yes, ma'am. Thank you.
Thank you.
It's 19th, right? Okay, good. Be scared me there for a second. I was still trying to make sure I write 2021 on these. Thank you.
Thank you. Okay.
Raise your right hand, get sworn in.
All right.
You not the swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth.
All right, sir. Could you please state your full name and your date of birth for the record? Thank you, sir. And sir, you've been charged with violating an injunction for protection against domestic violence. Do you understand that the maximum amount of time you could spend in jail on that crime would be 364 days in the Collier County Jail? And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? Do you understand all the rights you're giving up by entering into this plea? Are you entering into this plea because you believe it's in your best interest? Has anyone threatened you or made you any promises to cause you to enter into this plea? And you've been represented by Ms. Armpriester. Are you satisfied with her advice? Do you have any questions for her or for me before we finish your plea? Are you currently under the influence of any drugs, alcohol, or medications that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you understand that if you're not a United States citizen, that this plea would likely be used against you in a deportation proceeding? Do you also understand that violating an injunction for protection against domestic violence is enhanceable, which means there are circumstances where it can be charged as a felony? That's right, Mr. Rabb, isn't it? There's felony violation. I thought there were. Okay. All right. And Ms. Armpriester, do you stipulate to a factual basis and venue for the purpose of the plea? All right. Thank you. So the court will accept your plea, sir. We'll find that there is a factual basis for the plea and that venue is in Collier County. Also that your plea is freely, voluntarily, knowingly, and intelligently made and entered. To the charge of violating an injunction for protection against domestic violence, there will be an adjudication of guilt. You will pay the court costs, cost of prosecution, and public defender fees, which may be paid within 90 days, and $545 cost of investigation paid to the Collier County Sheriff's Office. Also, I'll give you 90 days to pay those costs too. Okay? Thank you. All right, good luck to you, sir. What's going on, Mac? Nothing?
He wants to wait for his attorney.
Oh, okay, that's fine. What's that?
I requested Mr. Elwer.
Oh, okay. Yeah, you're welcome to stay, Mr. Elwer. It takes a little while. Okay, that looks good. Thank you.
Judge, next would be Quincy Green, 20 MM 961.
Mr. Green, you ready, sir? All right. Oh, got somebody in Zoom. Mr. Clark just zoomed in. Good morning, Mr. Green.
We'd like to withdraw our previous plea of not guilty in exchange for a plea of no contest. Mr. Green was made to pay guilty, spent 12 months on probation with an early term at 6. Restitution is ordered and reserve found in the amount of $450. If you court cost prosecution and what I consider $50 cost of defense, and I may approach it.
Thank you. Who's the restitution paid to?
The state makes
Your Honor.
Sure. This is the best, if I get to stand up during these proceedings when you're way over there. Okay, got it. Thank you.
Yes, ma'am.
Raise your right hand to be sworn in. Sir.
You solemnly swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth. Thank you.
So can you just state your full name and your date of birth for the record? Let's make it public. And sir, you've been charged with petty theft. Do you understand the maximum time you could spend in jail on that charge would be 364 days in the Collier County Jail? And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? Do you understand all the rights you are giving up by entering into this plea? Are you entering into this plea because you believe it's in your best interest? You don't think it's in your best interest? Because if you don't, I'll give you a trial date. You have to say no. You have to say yes or no, because if you don't think this is a good idea, then the court doesn't think it's a good idea either. Has anybody threatened you or made you any promises to cause you to enter into this plea? And are you currently under the influence of any drugs, alcohol, or medication that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you take medication for depression? And does that depression affect your ability to understand and make a conscious decision to enter into this plea today? Okay, thank you. Do you understand that if you are not a United States citizen, that this plea would likely be used against you in a deportation proceeding? And do you also understand that petty theft is an enhanceable crime, which means that there are times when a theft can be charged as a felony, which would result in additional penalties, additional fines. That's about it. Understand that? Okay. Ms. Armpriester, you stipulate to affect factual basis and venue for the purpose of the plea?
Yes.
All right, so sir, the court will accept your plea, find that there is a factual basis for your plea and venue is in Collier County. Also that your plea is freely, voluntarily, knowingly, and intelligently made and entered. To the charge of petty theft, the court will, it's an adjudication, right? Okay, I didn't write that down. Adjudicate you guilty, sentence you to 12 months of supervised probation, which may terminate early after 6 months and upon the completion of all conditions. Restitution will be payable to the victim in the amount of $450. You'll also be responsible for the court costs of prosecution, and all applicable public defender fees. There will also be no contact with the victim, whose name will remain confidential, but it's been provided to the clerk. Okay? All right, thank you. Good luck to you, sir. A little tongue-tied this morning. A lot to say. Okay, looks good. Thank you. All right, this gentleman's name is Mr. Sweeney. All right, Mr. Sweeney, just give me a second to get caught up. Oh, Sweeting with a T. Sorry about that. I thought you said Sweeney. Sweeting, 20 CT 312. All right, sir. Thank you, Joe.
And Your Honor, the statement of the record, the record.
Okay, give me 1 second. Just to pass this over. There you go. All right. It looks like there's 3 counts. Are we pleading all 3, or what's the terms?
Yes, Your Honor, there's, it looks like it's stated on the file last year.
Okay, so you're gonna go forward on count 2 and I'll press count 1? Okay, perfect. Damage. So this is a DUI enhanced or DUI with a crash?
DUI with damage.
Okay, thank you. Okay. Okay, what are the terms?
Yes, Your Honor, is, so as to count 1 will be no cross the general DUI. Count 2 is DUI damage, adjudication, court cost of prosecution, $1,000 fine, 12 months driver's license suspension, 12-month probation, which may early terminate on successful completion at 6 months, 100 hours of community service.
Okay.
Victim impact panel, DUI school, substance abuse evaluation within 30 days of plea, following all recommendations, random testing, no alcohol provision, pending impoundment, and an order of restitution for the victim.
Yes.
In the plea that I heard there's some backlog with the evaluation, do we just have that scheduled within the 30 days, because it may not be possible for him to actually get completed within that amount of time?
I got it. Thank you. Boy, that's tiny. Yes. You don't need it? I'm just gonna put. Okay, all right. Boy, that print's small. I don't know how you can see that, Mr. Rabb. Even with my contacts in, I was like, Browser. You must have, like Clark Kent, maybe.
I've been compared it in many times.
I was just thinking that. You got the glasses, the dark hair. Maybe.
Never secret.
Oh, you never know. Okay, we need to get you sworn in, sir. All right, sir, could you please state your full name and your date of birth for the record? And sir, you've been charged with DUI with damage. You understand that that crime carries with it a maximum sentence of 270 days in the Collier County Jail. That's the most that could happen to you. That's not what's happening to you today, but if that is the maximum of time that you could serve if you were convicted of a DUI with damage. And knowing that, how do you wish to plead? Guilty, not guilty, or no contest? Have you read and signed a plea form? The piece of paper that tells you have a right to trial, right to call witnesses, right to remain silent, all that stuff. Do you understand all those rights that you're giving up by entering into this plea? Are you entering into this plea because you believe it's in your best interest? Do you understand that if you don't think it's in your best interest, I cannot accept this plea, which means I will give you a trial date? So do you think it is in your best interest to proceed with this plea, or would you like to have a trial? Thank you. Has anybody threatened you or made you any promises to cause you to enter into this plea? And you've been represented by Ms. Armpriester. Are you satisfied with her advice? And do you have any questions for her or for me before we continue with your plea? Are you currently under the influence of any drugs, alcohol, or medications that would affect your ability to enter into this plea? Do you suffer from any mental illnesses? Do you understand that if you are not a United States citizen, that this plea would likely be used against you in a deportation proceeding? Do you also understand that a DUI is an enhanceable crime, which means there are circumstances where it can be charged as a felony? It can also be used as a further suspension of your driving privileges if you continue to get multiple DUIs. Okay, thank you. Ms. Armpriester, you stipulate to a factual basis and venue for the purpose of the plea? All right, thank you. So the court will find that there is a factual basis for your plea and that venue is in Collier County. Also will accept your plea, find that it's freely, voluntarily, knowingly, and intelligently made and entered. To the charge of DUI with damage, the court will adjudicate you guilty. There will be a $1,000 fine plus court costs and the cost of prosecution. 12 months driver's license revocation, may obtain a work permit. 12 months probation, which may terminate early at 6 months and upon the successful completion of all conditions. I wrote down 100 hours of community service, victim impact panel, DUI school appropriate phase, substance abuse evaluation, follow all recommendations. To sign up for that evaluation within 30 days. Random urinalysis to breathalyzer upon request and at your own expense. No alcohol during the term of your probation. No alcohol in your residence. No visiting any bars, taverns, pubs, lounges, package stores, or places where alcohol is primarily served or sold. 10-day vehicle impound and restitution. Did we say reserve restitution payable to the victim? I just wrote down. My notes are terrible. No restitution. It's terrible. I can't even read my own notes. Restitution will be reserved and payable to the victim, who will remain confidential. Okay. Thank you. The longer this morning goes, the more tongue-tied on these pleas I'm going to be. I hope we don't have any more. Okay. And Mr. Rad, for the record, are you announcing an all pros on count one?
Yes, Your Honor. There is a no pros on count one. It is
20 CT 312?
20 CT 312.
Perfect. Thank you.
Judges, call Mr. Pryor's case so that I can confirm with Mr.
Sure. Do you want me to call Mr. Clark's case?
No,
Mr. Clark? No?
we still have Ms. Vita Merkley to handle.
Okay, Ms. Marceline, 20 mm 102?
Judge, this was not a mandatory requirement for Ms. Merkley. I did speak with her yesterday. Two issues present in this case. I did attempt to order a Russian translator and I forwarded that email to your JA. We have to have a date certain for the week of trial so that they can have their Russian interpreters present. And beyond that, I was made aware that the state is having an issue with their video, so I believe they're going to need to ask for a continuance, but at this point, I will address that.
The only way I can give you guys a date certain is if we do a bench trial. There's no way I can give you a date certain with the jury trial.
I get that.
It's not possible. It's not possible in the near future, I don't think.
I don't know how that happens, because it's me as the defense attorney to order an interpreter, and I know that we're going to have one for Ms. Merkley. So the interpreter's office told me that once I had a more specific date, that they could give us our interpreter. So I'm not sure if that's something Your Honor can handle with court admin or how we want to proceed, but.
To ask them to find me a Russian interpreter?
Well, no, they can find one.
People up above that are listening to this right now are laughing. They're like, Judge Nicole's going to find a Russian interpreter through court administration. That won't happen.
Whoever's in charge of the interpreters last I checked with court admin.
Really? I thought there was like a head person for the interpreters and court members. Thank you.
I thought that was through court administration, but you might honestly pardon my ignorance.
I have no-
But seeing.
I have no idea. Do you know, Joe? Isn't this somebody up in Fort Myers that's in charge of the interpreters? There we go, Mac knows. So you gotta ask Mac. He'll find you an interpreter.
I'm merely the messenger here, Judge. I can't have an interpreter for my client until I'm given a date by the court and Mr. Ramsey can continue.
It's like, but I can't give you a date certain. There's no way I can. And Mr. Rob, just trying to think this through logically.
Your Honor, I have absolutely no say on the interpreter.
No, I know that. But what's the reason for the request for the continuance?
As to the videos, Walmart, for whatever reason, has a specific viewer or their media player that will only play their videos. In the video files that we were sent, we were not sent their viewer along with their videos. In other words, if we click on them, we can attempt to play them in any medium. Neither side would be able to review those videos without the player being attached. We have requested that player be resent to us to allow both sides to review the video.
But Judge, this case is over a year old.
It is, it's 400 days old.
I would have thought that they would have attempted to view the video before filing the decision or not ready for trial, so the defense is prepared to go without the video.
I feel like a large amount of the petty theft cases that we get out of Walmart. So I'm surprised that they wouldn't have already provided a media player for their things, because they seem to be pretty heavy advocates for prosecuting people who steal from them.
They generally send a particular, so they send a zip file
Mhm.
with every single video attachment from each camera, along with a particular viewer for that drive. I've tried using the same video viewer and other files to upload them, and it won't upload for whatever reason. But the actual zip file that we received for this case only contains the video files and not the actual viewer.
Okay. So there's a lot of difficulties with this case. Number one, we don't have the video, but it's possible that we could have the video by the date of trial. And the defense is objecting to a continuance. And I'm going to take it that the defense would object to a continuance even if we do get that video and that video can be played. Because what I don't want is I don't want to hold the state's feet to the fire and say, Mr. Rab, we're going to have a trial. It's happening. Here's your date. And then Walmart says, we figured it out. We're giving you the video. You pass it over to Ms. Armpriester, and she says, well, now we have a video that shows my client stealing from Walmart, so I need a continuance on this, and to which I'm going to say no. Yes.
For the record, this is set for your second week.
Mhm.
You would like to put it on your calendar call, and so we will certainly work diligently to get those video files for both sides to review.
Okay.
In addition to that, we do have loss prevention officers provide testimony. It is the court's decision to move forward with that case for whatever reason we don't have the files. That's a decision for the state to make whether or not to proceed at that point.
Okay.
The state's request will be a continuance, but if the court is going to push us to trial, we can certainly set it.
I'm going to push, and I'm going to give you a date certain. So the date certain will be March 5th, Friday, March the 5th.
Judge, I'm being told that with these types of jury trials, we need 2 days, especially to pick a jury. So should we set it for March 4th and 5th so that we're safe with the interpreter, or just 1 day, that's it, whatever happens?
How many
I
witnesses?
just want to be sure whatever I tell the interpreter.
I'm like, how many witnesses do we have to a petty theft? We have maybe a person who is going to qualify the video, who says that I saw the theft and this is the person, and ID them. I just can't imagine that this is a 2-day trial.
Along with the loss prevention officer, the state probably won't have more than 2 or 3 witnesses, so can't imagine the testimony being substantially long.
I don't see this being a 2-day trial. If it goes 2 days, I know that the judge that's behind me is not going to start a trial on Monday. So I will get permission from Judge Foster, if it goes for 2 days, to say, Judge Foster, we have another half day that we need. Can we please just let it go into Monday? I can't imagine that he would say no.
That works for me.
But
I'm sure. I just wanted to have a backup.
yes, there's always Saturday. I know that jurors love to come in on Saturday, don't they?
It's their favorite day.
The clerk loves it. I know Joe's in on Saturday, so he'll be here. I think we can do this trial in a day. I have confidence in you guys, even with an interpreter.
It does appear that there are cases set for it that are likely to go
Also sounds like there might be a possible resolution if everybody has problems. Maybe. Just my thought out loud today. But yes, we will make a finding on the record that this lady needs a Russian interpreter. And then they're going to bring a live person in to interpret for her, right?
Yeah.
Perfect. Which we probably would need, even if you guys came up with some type of a plea, we would need her to be able to understand.
Her English is,
She was over Zoom the other day, right?
and it's when we use legalese terms and when people get going real fast.
Like I do?
She can't keep up, so that's where the interpreter comes in. I've noticed when I'm speaking to her about very basic things, where to be, what to do, her English is lovely. But
Yes.
when we start talking about the case and other things, it can get very overwhelming. And then I am not easy to understand her, because then her English starts to sound more like Russian.
Yes. I remember her. I thought she seemed to be, at least understand what we were doing the other day.
She does make that very time.
Just for the record, the state has offered her and the state will offer her.
I will pass that on to her.
That sounds like a solution, but yes, we can cancel March 2nd because we're setting it for a date certain. And I'm going to need to be reminded on March 2nd that I set this, but I may set a backup trial just because it sounds like there's maybe potential resolution. Has the state's offer of diversion been conveyed to her? Multiple times. Well, she may want a trial. Just like the victim in your case who doesn't want to allow you to make an offer to the defense because she wants a trial. Yeah, no, I think it's actually a good idea to put it on the record. And in all honesty, Ms. Armpriester, your client's mind may change in the event that we have a video that suggests that maybe there might be a difficulty at the trial for her. So who knows?
I don't think so, but I will relay all this to her.
Never know, right? Okay.
Judge, next would be John Christopher Spears, 20
Okay.
Unfortunately, Your Honor, through my efforts and my investigators' efforts, we have not been able to make contact for him.
20 CT 802. Let's just pull it up.
I reached out to his bail bond, that's AA alligator bond. I've not heard back from them, neither is my investigator. I just don't have any representation. I would request if the court is inclined to issue a warrant that be an ROR attached.
Well, I'm looking at this history. So very similar to the others before him, that he's failed to appear multiple times. It looks like he's failed to appear pretty much the entire time, which is why the court required his presence today, just to make sure that he wasn't ignoring his obligations to this court. So the court will issue a bench warrant. It'll be the same bond as before with the other individuals, $2,500. Mr. Rabb, any comment?
No.
That works for you? Okay. All right, who else do we have?
I just need a 5-minute continuance to confer with Mr. Rabb and Mr. Ryan.
Okay. Why don't I address Mr. Clark's issue first so that he can be on his way, his case. Mr. Clark, you're here for, I know the joke, by the way.
Come on.
Reva Monteguido, 20 mm, 19 mm, 1673.
Well,
Yes.
Judge, did Mr. Did he show in court today by any chance?
Is Mr. Waldo, oh my God, I'm having a hard time with his last name. Is Mr. Waldo Leva Monteguido here? Looks like he doesn't feel like joining us either, like 3 other individuals today, Mr. Clark, and I'm guessing that you can't find him either.
Your
Still
Honor,
missing.
I made attempts based on the fact that you did set this as a mandatory appearance, and I did contact his bondsman. I haven't heard any information back from them. At this point, Judge, I I don't know exactly what to do. Obviously, you can look at his history and make your own determination. However, I would just ask for another pretrial conference on his behalf.
Oh, boy. It's the same situation, Mr. Clark, as we've had with everybody else here today. He hasn't appeared at all since the beginning of his case, which is almost 2 years old. I'm actually really surprised that nobody else has bench warranted him, although maybe that's my fault that I've let him slide, probably. Not let him slide this time. Bench warrant $2,500 bond. And I appreciate your efforts, Mr. Clark. I think that you've been trying to find him, but it's his responsibility to make himself available to the court when it's required and to pay attention to what's going on, and also to be in contact with you to ask you what's going on. And thus far, he hasn't done that. So we're going to have to find him and bring him in, and then we can go from there. Okay?
Yes, Judge, I understand. We have to find Waldo.
We have to find, well, I knew he was going to say that. I knew it was coming. Have a great weekend. Thank you.
Thank you, Judge. You have a great weekend.
All right. Thank you. Okay. You wanted a minute? I'm just going to take a short recess. I'm going to go get some more water. I'll be right back.
Raxford is in recess. Whatever you want.
Okay, I'll be back in about a half hour.
Okay.
No.
All right, court is back in session.
Good morning, everyone again. You can be seated. All right. We can't yet.
I want to do that.
We will in a minute. Okay. I'm showing that Mr. Caro's up for a plea. Anybody heard from her?
That was Miss Fish's.
Oh, that was Miss Fish. I just didn't cross it off. Got it. I also showed that there are two pro se individuals.
Yes, Your Honor, I believe that those are likely to be that ones.
Okay. They tried to start without you. I said, we're ready to go. I go, we can't.
They could have, my computer, I didn't even lock the computer. Sorry.
Do you have to lock it?
Yeah.
You can type things in there? Well, I wouldn't do that. What's that? A gnome?
Yeah, right.
Like the gnomes are gonna come out and type things in there?
She would have finished the docket and be like, no. Judge,
Magical people? All right, we're getting there. We are. I did too. I was like, oh, all I have is ice cubes in here. I'm like, I just need more water. I usually have a big bottle of it with me, and I forgot to grab it this morning. So. Yeah, this has definitely been a long week, hasn't it? Yeah. Mm-hmm. Very busy. We're ready for you guys whenever you're ready.
I'm Robert Filer.
Sure. You come on up, Mr. Filer. 20mm752. How are you today, Mr. Filer?
Great, how are you going?
Pretty good. Pretty good so far.
Guys, we'd like to leave this set for trial. I do believe Mr. Rabb and I will be able to come to some sort of an agreement, however, we need more time.
Is it set for the first week or second week?
Second.
Okay. Well, why don't we set it for the calendar call on on the 1st, I'm sorry, at 9 a.m. And then if you do come to a resolution, I could take a plea that morning. If it's resolved. If not, we can just determine whether it's going to go to trial that week. Either way, we'll figure it out for you, sir. Okay, you're welcome. Thank you.
You want that at 9?
Yes, ma'am. I have Michael Colhagen and Avathea Boucher.
You know what, Your Honor, I believe Michael Colhagen is from prior docket. That's right.
Oh, that's right. Yes, because remember he wasn't here and we called and we got him. He said, his voicemail said, "Hi, this is Michael Colhagen." And I said, "This is Judge Nicola. You need to be in court on Friday morning at 9 a.m. or otherwise bad things are going to happen." And bad things are probably going to happen because he's not here, which means it's going to be a bench warrant. 19 CT 2634. He was ordered to be here this morning. Left him the message myself. Wasn't here last time. He's obviously not coming here today. So it will be a bench warrant. This is a DUI second. It will be a $5,000 bond. All right, that solves that one. What about Avathea, Vivathea Boucher, 20 CT 706?
I believe that was simply a pro se appearance.
I don't think so either. Of course. Yes, that was was that your last case?
I think so.
Wait a minute, what about Suhail Abdel Rahman?
Judge, that was continued.
Oh, it was?
Via stipulation for myself and Mr. Stewart, there's a witness issue. I believe it was put on your 422 pre-trial.
Oh, okay. It's still showing up on my desktop. And was Philip Brodowski, was he the co-defendant with the other Brodowski?
Yes.
Okay.
That was moved to the 422 as well.
All right, so that is your last case, so thank you. Have a good weekend, everybody. All right, so let's look at Ms. Boucher and see what's been up with her. Oh, and you sound like you're getting a cold. You coughing?
I think it's just that.
Oh, really? Oh, that's no fun. Yeah, there's a lot of pollen in the air right now, isn't there? Okay, this case is almost a year old, and let's see. You need like an Allegra.
Yeah.
Driving license suspended, canceled, or revoked. Second. This was was this a felony drop? Looks like it at first was filed, maybe it says felony arraignment. Oh, and then it was transferred over here. Okay. Strange. All right. And information filed. Notice to appear. Pled not guilty. 6/11/20. It does not look to me like she has appeared ever. I'm not seeing, other than at the initial arraignment to enter a plea of not guilty, but she hasn't appeared at all. This will be a $2,500 bench warrant. Whenever you're ready. That's the last one. Of course. Oh, okay. Yeah, the calendar call. Okay.
Your Honor,
Yes, sir.
may I just confirm anything that's set for next week that doesn't go because Judge Foster takes the week, we'll just recalendar it to March 1st week? Is that intent?
Well, maybe what we could do is take a look at that and see whether the cases that are set for next week are going to be older than the ones that are set for the March 1st week, because I kind of would like to prioritize them depending on how old they are. We don't have anyone in custody that I know of, right?
Correct, Your Honor. And I tried doing that. All of the later cases that are set for the second, except for Mr. Eller's case in week 2, all of the cases for next week are earlier than the second.
Oh, okay.
So they will take priority.
Yeah, we'll do that. Yeah, we'll move them from this coming Monday, if we don't end up having any trials next week, to the 1st, and then we can address them then.
I don't know what we do with
The last 3 cases.
Filer.
Mr. Filer, what do we do with Mr. Filer?
We'll see the March 1st.
Yes, set him for March 1st at 9 a.m. It's easier to like look at him and I'm like, okay, I remember what I did with this case. Yes. It's been a very, very busy week, which is really weird with, with COVID and everything. You think that things would be slower, but I think they're busier right now. They really are, aren't they? The representation was that he was already continued.
My understanding is that Mr. Stewart was on pre-serve and stipulated.
April 19th at 10 o'clock for DD3.
Perfect. Okay. Yeah, it was still on my desktop. I issued a bench warrant for her, $2,500 bench warrant.
Sometimes it's trying to get the dates in.
I know. That's okay. All right, we're gonna go off the record. 2,500, yep. All right, so that we saw